Good evening. My name is Mark Leading, and I'm a member of the Business Association here on campus. Today we have the distinct honor of Mr. Chip Leone and Mr. Woodward. And I want to let you guys take it away. Thank you so much.
Good. Chip, why don't you talk about the meeting?
Okay, first I want to give a little bit of history about myself. So, that's okay, Professor.
Absolutely. Yeah.
So I'm actually a local being in the Bay Area. I was born and raised in San Jose. I'm actually a fifth generation San Josean, so my family goes way, way back. I started at Morrison and Forster long before you guys were born. And I'm in the corporate finance group. I was past chair of our corporate finance group. Now I chair our private equity fund group worldwide. But in my spare time, which is about, I would say at least a quarter of my time, probably a little bit more, I'm currently serving as chair of the ABA Business Law section. And that it represents about 50,000 members, many of which are students as well, probably about 38,000 lawyers, and then students and associates. Associates include lawyers from Canada. Believe it or not, we have lots of foreign lawyers that are members of our section, and they're associate members because they're not members of a state bar. So what I'm here to talk about first initially, and then Bill and I were going to go through the problems, is to talk about our upcoming being the business law section spring meeting, which is in San Francisco, and you'll see in the materials here that you would have. Starting April 15th is our reception in the evening, and then we have CLE programs, which you'll list. There's probably 60 programs, and committee meetings and subcommittee meetings. And if I were a student, which I was many years ago, and I knew that this opportunity was available to me, I would have gone. I would have gone because there is so much you could learn and be involved with and participate. We're a very open group. There isn't one meeting, maybe except for corporate laws, because that's sort of a select group of individuals who draft the Model Business Act. Other than that, everything's open. All the meetings are open, all the CLE programs are open. So if you pull this out, let me just walk you through this briefly. So Wednesday there's a reception, beer and basics, from 4 to 6. You can see where it's located. This is all, so all the meetings and will be held at the Marriott Marquis and the Intercontinental Hotel, which is just around the corner from the Marriott Marquis. If you see at the top, there's registration. I would ask that you register. You can register the day of. You can show up and register. But it helps us, frankly, to keep track of food and other things if you can register beforehand. And I would do that, even if you're not planning to be every meeting, just register beforehand.
You have a name tag to get into into anything.
Right.
So you need to.
You'll have to register either online and then show up and pick it up, or just show up at the registration desk. And then Thursday and Friday are the more substantive activities. We even have programs, look at how to network, law student speed networking, icebreaker reception. Then Friday we have program pro bono to build lawyer competencies. Professor Woodward chairs our pro bono committee. There's a young lawyer committee meeting. So, and then we have all these various receptions. All the receptions are free. There's lots of food and lots of drink. So I know when I was a law student, I didn't have any money, and anything free food, I was there if I knew about it. So, but apart from that, this business law section has 19 administrative committees, pro bono committee being one of them. It has 50 substantive committees. So any subject that you guys are interested in, I will assure you there will be some CLE program or a committee meeting or a subcommittee meeting on a topic of law that you'd be interested in. And to me, what I'd be fascinated about, because as a student I didn't even know these things, and quite honestly as a young lawyer I really didn't know much about this, is that the committee meetings and the subcommittee meetings actually can be so much substantively interesting, even more so than the CLE programs, because in some of these committee meetings there's some business, but there's often there's educational aspects to it. So maybe there's a drafting committee meeting in one of the subcommittees, and they're drafting amendments to the model limited liability company operating agreement. So you think, well, okay, I took business orgs, and they had 1 week, maybe 2 on LLCs. So what is a limited liability company? What's it all about? Practical issues. So what I would encourage you to do is look at, and we have different ways to produce the information, but this is the chronological of all the meetings, committee meetings, networking, so it's quite extensive. I think there's 500 committee and subcommittee meetings in addition to the CLE programs. So
You can pick that up on the website.
yeah, all this is on the website. Yeah. And so I would encourage you to, if there's an area of law you're interested in, look for that committee, find out where the committee's having meetings, and go to that meeting. Because I actually think it will be a very enriching experience. You're going to meet lots of lawyers. They're always really friendly. Every lawyer loves to have students come into their meeting and think it's really cool. I do. And because you're interested in something. And the other great thing about it is, even as a young lawyer, it's very open to ideas. I mean, no one has a monopoly on ideas, even though there are luminaries like Professor Woodward and others that are in these committees. They let you talk, and you can say anything you want to say, and they don't make you feel stupid, and they don't make you feel insecure. So I really encourage. I'm going to evangelist about these section meetings. I think it's just a great opportunity for you all to get an idea of what it means to be, frankly, a lawyer. And the collaboration. Here's the other thing I will tell you. I tell this to all the associates, young associates that I work with. Practicing law is, they talk about the unforgiving mistress, at least in a male-dominated world, it's unforgiving mistress, like it's unforgiving everything now. It is, even though I'm not a litigator, it is adversarial. And it can be a grind. It was for me. And for me, one of the most enlightening things was to be involved. I initially started out at the California State Bar. But when you can be involved in activities where you collaborate with other lawyers, to me, it's just one of the greatest experiences and great feelings. Here's guys that maybe you're negotiating against with, and all of a sudden you're in a committee and you're collaborating on maybe writing a comment letter to the SEC on one of the proposed rules. UCC, I mean, you guys always are modifying UCC. Seems like. We've got a drafting project right now on the new tribal security interest in tribal UCC. I don't exactly remember what it is, but so I'll get off my soapbox. But let me ask if you guys have any questions. And no such thing as a dumb question. Feel free to ask. But anybody have any questions about this program coming up?
Can I stick something in there?
Absolutely, stick away.
All right. To give you an example of the committee meeting stuff, do you all remember the Madoff case? Remember Bernie Madoff? Okay. So he's paying out money, and then he doesn't have enough money to pay out, so all these people get screwed. It went into a bankruptcy settlement, and the receiver was in charge of trying to get money back from the people that got paid off so that they could pay some of the people that never got paid off. It was this amazing, kind of unprecedented in modern times kind of bankruptcy. And I walked into this meeting, it was a bankruptcy committee meeting, and there he was talking to the group, the receiver, talking about what he was going through and et cetera, et cetera. I mean, it was just absolutely amazing. I think you were there.
I chair the working group on
There you
asset
go.
management.
There you go.
So
There you go.
we're empowered the receiver, as well as the dryer receiver, the Petters receiver, folks from Maine Justice, the SEC,
Yeah.
executive officers here, they're all on our committee.
So, yeah.
And yeah, we actually are having a working group meeting here at Golden Gate for a full day, the day before the meeting starts, where we're drafting a guidebook for these cases that we're hoping FTC.
When you say the cases, sorry, I'm not going to digress, but are these like pyramid scheme type cases? That's what I call them.
Many of them are Ponzi schemes, but
Yeah.
not all of them.
Yeah, okay.
So there's the Rothstein
Yeah.
case, which is a big law firm down in Florida. Yeah, anytime there's a crime or a civil regulatory like securities problem and the government goes in and grabs the assets and there's a bankruptcy. Now you have two areas of law that are completely clashing. The government wants to take all the assets to pay the victims, and the bankruptcy wants to take all the assets to pay the creditors. And we have to figure out how to make those two areas of law work together. So it's
Anyway, you can stumble
It's
into
pretty
a committee.
amazing what
You can
you can
stumble
stumble
into a
into.
committee meeting and really, get your eyes open. So that's one thing. Another thing is we have a division called the Young Lawyers Division, and they have a whole line of programming that's very basic stuff. And you should keep your eye open for that, because that's sort of how do you negotiate an agreement? How do you do this? How do you do that? It's real basic stuff that would be quite easily accessible to any law student. And the third thing is, if you go to committee meetings, you can sign up for committees as a member of the section. If you join the section, you can sign up for a committee and you can volunteer to do stuff. So my committee, for example, one of the things that we do is we try to write some articles for our magazine about pro bono work. You can do that. And you can get a byline, you can start talking to people, showing people how your work is, because if somebody sees your work, they can write a far more compelling letter in your behalf for employment than if they just know you. You know, oh, this is my daughter, I'm going to write a letter of recommendation for her. One of the things that we try to emphasize is if you can get yourself a job doing something, and that's just going to the committee chair, saying, I'm on your committee, I'd like to do something, find something for me to do. You can really advance the ball in your own behalf. So anyway.
Yeah.
Chip,
Go
can
ahead,
I
Karen.
emphasize one thing on your
Please.
list, just so that you all know how this works? When you see this mention of the law student speed networking, this is a really awesome event. Essentially what happens is there's a large room and the tables like this are put around, usually in a U or a circle. On the inside of the circle are sitting highly experienced leaders throughout the ABA business law section. And on the outside, doing musical chairs, are law students. You sit down, it's not like a cocktail party, my name is so-and-so. You literally sit down next to someone and say, hi, I'm so-and-so, here's what I'm interested in, what advice do you have for me? And they will give you your advice, and then 5 minutes later, you move on to the next person and say, hi, I'm so-and-so, I'm interested in this, and what advice? And you can get the most amazing, really specific advice in this, hour that they have here, hour and a half. Much more than the idea of, well, networking means I go to cocktail parties and shake hands and hand out my card and nobody remembers me the next day. So I just wanted to
But to that
emphasize
point,
It's a
you
really-
hand out your card, no one remembers you.
Exactly.
Follow up, because even we as lawyers that go to networking events, we tell our people, hey, if you don't follow up, they're going to forget you anyway. So we have to follow up, you follow up. I think if you do follow up, I think you actually good things can happen. The last thing I'll leave you with is my sort of anecdotal own personal experience, because someone asked me, I get asked all the time, hey, how'd you become chair of the business law section? And you ask anybody who knows me, it's not something I wanted to do. In fact, when the nominating committee called me to tell me that they were unanimously appointed me to be the secretary, which we have a 4-year leadership ladder, and that means I'll ultimately be the chair, I said 2 things. One, if it was unanimous, it had to be on the 4th ballot. And then the second thing I said was, I don't want to do it. And the response was precisely. Sometimes it's, these things are political and people really, this is their goal in life and they do things that maybe are contrived. And I really don't want to do it. But at the end, you have to want to do it in the end if you're going to do, I think, if you're going to do a good job. But someone asked me, how'd you even get there? And I point to one incident when I was first as a lawyer. This is, again, before you guys were born. In 1982, California had adopted the Revised Uniform Limited Liability Company Act, and I was asked to speak on it at a continuing education bar, CB program. And the moderator for the CB program was a guy named John Murphy, who to this day is a very dear friend. He had dinner with us on Saturday night. And he, myself, a fellow by the name of Doc Merrill, and a guy named Joe Rodowski, we showed up, and he said, hey, this is great. Hey, how come none of you guys are members of the partnerships committee of the state bar? And the 3 of us look at each other and go, we didn't even know there was one. We've been practicing lawyers for a while. So unbeknownst to us, after we did the program, all 3 of us joined the committee. All 3 of us ended up serendipitously became chairs, back-to-back-to-back chairs. During my tenure, we happened to be this new animal, limited liability companies. What are those? So I actually spent, at my chairmanship, pretty much writing with 2 others, the uniform, our Limited Liability Company Act. So I got involved with that. I met a bunch of people who were there. And then I said, oh, you're going to be on panels at the ABA. And I got on panels at the ABA. Oh, can you be active in the partnerships committee? Well, sure, I could do that. And then someone said, well, hey, what about, you do a lot of venture capital, can you be on the venture capital committee? Sure. And then the chairman came to me and said, of that committee, said, hey, would you be the chair of the committee? I go, why? He goes, well, you're the one guy who's doing something. I go, okay, sure. I'm telling you, that's how it works. There's not a plan. I didn't have a plan. So when I tell law students, there are opportunities out there, still opportunities out there. Some will argue that they may be harder to come by, but they are there. You just have to work at it, and you will find it, and you will find your place. And I mean that in all sincerity. So, I hope and expect to see you guys all at this meeting sometime. And if you see me, I want you to come up to me and say hello.
Butt in.
Okay? All right, I expect that. And I'll introduce you to whoever I'm talking to. Okay? And if I don't know their name, you'll know I didn't introduce you. You play along with me if I forget. Okay.
They have a very, 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 I can't emphasize enough, welcoming attitude towards law students, young lawyers, etc. And it's just, you know, it's regenerating the group is really what it is. So you won't find a more welcoming group than this. You know, it's kind of nice. It's kind of nice to be wanted. You know. Anyway, don't you have some questions? I mean, you can drop in and drop out. I mean, from here, I guess it's a two-stop BART ride to get to where the hotel is. I think that's where it is. I think it's at the Civic Center.
It's down near Muscogee, isn't it? Almost walking. Can you walk to the market from here?
Yeah.
Yeah, I think so.
Yeah.
Yeah.
So you know,
Fair enough.
come in and out. You know, and just hang on to your name tag.
Yeah, Jared?
Yeah, I had a question. For a student who attends this event, talks to a lawyer, gets a card, and wants to follow up like you mentioned, what's the best thing to say in the follow-up to keep the dialogue going?
Good question.
Mm-hmm.
Well, obviously, if you talked about a particular subject, whatever that is, you can remind them of that subject, because that also helps them, that he or she remind them of your conversation, who you are. If there was something of interest, that you can express that was interesting. If it's somebody that's in the area locally, maybe you could follow up and say, hey, I would love to buy you a cup of coffee. I'm sure they would buy it for you, but offer to buy a cup of coffee to talk more about their practice if that's what you're interested in.
You could ask them to nose around for something for you to do. You know, law students can do research, they can write. There's a bunch of things that you can do that don't require you to be lawyers. And as I said before, if you can manage to secure for yourself some kind of a job, I've used law students through the ABA to do a bunch of research things. You know, again, you wind up working with other people, and the other people you're working with are lawyers, and that's a good thing. So I mean, I would add to what Chip said. Can you think of something that will allow me to do something for this group? You know, whatever the committee is, whatever it is, and see what happens. You know, but you can't be. I guess you could be overly pushy. You could walk into that meeting with a pile of resumes, but you don't want to do that.
Yeah.
You know, you could be, but don't be shy. I mean, that's really the real point. I mean, you know, there's a limit to how aggressive you can be, but you're not going to hit that limit.
Yeah, people enjoy you coming up and introducing
Absolutely.
yourselves.
Absolutely. And you know, I mean, think about lawyers with law students. I mean, they think they're big cheeses, you know, and they're gonna teach you some wisdom or something like that. Sorry. You know, you got the idea.
You're not excluded from that.
No, of course not. But you know, lawyers like to talk to law students because they, you know, they're like the king of the heap compared to law students. So there's sort of a natural affinity that they'll have, and you know, you just exploit it. I mean, that's really you should go there and take advantage of everything you can find.
Yeah, and to do that is actually go to a committee or subcommittee meeting. I mean, and I'm sure that coming to your working group is not a great example, because that's hard because you guys are all like this. But I mean, sitting in the back learning would be. I mean, I would love to do that, and I don't know if you encourage people to do that.
Yeah, you know, the other thing I would add is, lest you be concerned that you have nothing to contribute, there are things that a bright, industrious person can do without really much substantive knowledge, if that's your concern. Many of the larger committees, for example, will have a liaison in which anyone who says, gee, I'd like to do something, will be sent to the liaison. For example, I chair the Publications and Content Subcommittee, so I'm in charge of liaising for people. So if a young lawyer or a law student comes to our committee, someone will call me and say, I have a person who wants to get involved, do you have a way for them to get involved? So depending on what their experience is, I can target them to the right area within our committee, which is business bankruptcy, if that's your interest. So, for example, one of the easiest ways people get involved is materials coordinator. There's a program coming up. We simply need someone who can put all the materials together, make them look nice, coordinate everything, put it in the same font, and you actually get a byline as being the materials coordinator for the program. And what you show is that you're willing to volunteer, you actually step up and do the job, and you do it well. And then you've just developed a reputation as being a doer. And someone will then reach out to you and say, well, remember so-and-so who did this? Maybe they could help with this project or that project. And you'll start with the baby steps and go up from there. So I encourage you to do that.
No questions? Yes.
I think a lot of these are really good opportunities. I wanted to ask a little bit more about the Young Lawyer Committee. A lot of these other committees seem like it's great to hear the more experienced attorneys out there in the world do what they're doing. What's the difference between the Young Lawyer Committee and what kind of stuff do
The
they?
young lawyer, it's a division, it's not a committee.
We actually have a young lawyer committee though.
Oh, we do?
I'm only reading
Yeah.
off of this.
Oh,
Yeah.
sorry.
No, that's all right. We do have a young lawyer division, as Professor Woodward mentioned, but within our section we have a young lawyer committee. Mac McCoy. I mean, here's an example.
There you
So
go.
Mac McCoy was our most recent committee chair. He was so awesome. I mean, so he's a young lawyer. So young lawyer, I think, is defined as someone under 35.
Under 35 or...
So usually 10 years of practice type of thing. And Mac was so fabulous. You can imagine someone like me. You guys follow me on Twitter? You don't know because I don't have a Twitter account. I should. I'm supposed to. Actually, I have one, but I don't follow me because I don't post. But this guy is very savvy with social media and social. So I mean, he brought a lot of ideas to our section. Karen said, these guys are doer. So great. You didn't sign up, but guess what? You're competent. You're doing things, and so all of a sudden he's on our council. I mean, I'm gonna say one of the youngest guys, but he's a council member. We have 20 council members. And there's 5 that serve 4-year terms. So he's there, and so what I would tell you is that committee. Some of the things that it does is this law student programming. They're involved in that. They're involved in what they call practice basics. We used to do a program. I think we're doing it in a different way. But we used to have a practice basic program the day before the spring meeting, where it would be for basically young lawyers who would come, and it's the basics, right? How you write a contract, how you draft an LLC agreement, how you do a corporate financing transaction, how you do a real estate transaction, things like that. So it's a great committee to get involved with as a young lawyer, because frankly it's designed to be responsive to the things that a young lawyer is interested in. To be involved with.
Yeah, I mean, the other thing is, for Mac, this is Mac McCoy, 32, 33. If I needed a Florida lawyer, I know Mac. I'd call Mac. And, from his perspective, man, that's a big deal, right? I mean, that's business. And so a piece of, your networking at this stage is not that, but their networking is that. I mean, and part of it is part of it's just for the sheer pleasure of working with other lawyers that are real smart and industrious. But part of it is the networking is, who do I know in Florida? Well, Mac McCoy is somebody. I'll call him up, and lo and behold, Mac winds up with a new client, and that's just really helpful because you will find. Almost, I don't know how often it'll happen if you're in practice, but you get calls all the time for lawyers that are out of your jurisdiction.
All the time. The story I tell, and I have lots of referrals, And what I say is, so when I was asked to be the chair, I knew it was going to take a significant amount of resources, and I had to go to our chairman, and the chairman asked me fairly, well, do we get business out of this? He knows that we would do it anyway, because I'm actually one of 3 Morrison and Forster partners over the last 75 years who's been chair of this committee, so our firm has been committed to this, bringing back to the profession, regardless of whether or not we get any business. And what I told him was, I have actually quite a bit, but that's not why I do what I do. And there's an old saying, if you do the right thing for the right reasons, good things happen. And that's what happens, as Professor Wood was saying, that's what happens. But I will tell you, people who do things for the wrong reasons, I'm coming just to network, that's all. I'm not contributing, I'm just here to try to get business. Wrong reason to come to this. So it's a byproduct, and it's a good byproduct, and it's often is a byproduct that occurs often, but that is not the reason why we do what we do, and it's not the reason why anyone should come to this. It's an enriching environment and experience, and like I said, Karen, Bill have been talking about everything they're saying about talking about contributing, how ways you can be active, involved. That is enriching in and of itself, but that's what we do, and I think you gain a lot from that.
Yeah.
If you do it that way.
I mean, and you know, Karen knows this better than I do more recently, but when the UCC was in redrafting mode, being involved with that means that you can put your fingerprints on it, which is really neat. I mean, it's just really neat. And so, and they're always working on these projects that will eventually turn into legislation. And so, you know, if you contribute to the phrasing of something and make it clearer, I mean, that's really terrific. I mean, that's really neat stuff. And so, you know, I think most people that I know do this for the kind of the pleasure and intellectual stimulation of doing it. Some people also do it to have influence, and some people do it, you know, and the networking part is really, it really is.
Well, we have great CLE programs.
Yeah,
I mean, just going for the CLE is great.
Yeah.
But the other thing I always cracked is when I wrote the LCF for California, I always said I wanted, and I'm sure you guys have this on the UCC. Someone called me and said, "Hey, this is what it says in the statute," and I said, "Yeah, I think this is what it means." And they said, "How do you know?" I always wanted to say this. Well, because I wrote it. Little facetious, but I did say that.
Yeah.
Yeah. But I know all you, the professors, usually professors. It seems like they're real involved in the UCC. I know there's a professor up in Gonzaga, and he's active, and all you guys are. And you guys are all, yeah, I know what it says because I wrote it. And I think it's hard though. Do you ever find, I'm digressing because I'm always curious. So if you're on a working group and you're drafting, do you find it difficult that are you not allowed to be sort of the scholar now to criticize, write a law review article on something?
Well, I think what
That's always
they
a
tend
challenge.
to do is they want to have a reporter, a professor chairing something or being reporter because they
Right.
bring not only, the depth of focus, but also the neutrality
Right.
that is really critical to bridge the gap between the different interests that are there. For example, on the asset forfeiture work right now, I feel compelled not to write the law review article. I
Yeah.
want to write
Yeah.
advocating a position because a part of my role is ensuring that everyone remains in dialogue. And if I say something that the Justice Department isn't going to like,
Yeah.
I just torpedo the committee. But once the guidebook is written and we're out and we are moving towards legislation and rulemaking, then I
Then
can
you
do
free-
that. But
yeah.
I can't do it right now. Have you found that too? You can write things that are more neutral, like describing what's going on and why it's going on and everything.
Yeah.
You've got,
Can.
you've
yeah.
had more experience with that.
I want to tee up the ethics stuff.
Speaking of ethics.
Yeah. And one of the reasons we're doing this is I had Chip to my contract drafting class about a year ago, and we went into. I asked him the question: how often do you encounter an ethics problem in practice? And if I'm not mistaken, he says something like about once a week.
Mm-hmm.
And the disjoint between that and what happens at law school in ethics is just, the gap is like yawning gap. And so there are people that say you should teach ethics pervasively in all of your courses. It doesn't happen that much. But I had a consultation matter where a lawyer blew the statute of limitations, didn't tell the client, went down a road and then got sued for malpractice. And the ethics issues that emerge from that kind of a problem are really interesting, and I've never seen them encountered in law school. So that's really where we're starting out. So I want to put up on the board what we got here, what's going on. Okay. Okay.
Well, so the
PowerPoint.
picture
Okay,
first
got
or the
it.
words?
There we go. Okay. So the problem is basically this. We have a.
I'll make the screen for you.
What have I done?
Just make it this.
Okay.
And then if you want to toggle
Yeah,
over to
yeah,
this,
I
just
got
press
that,
the
right.
thing that says
Okay.
document camera.
I'm going to put on the verbal version of this so that you can see what I'm going to talk about. So the client, Mr. Jones, is represented in a personal injury case, 50-50 liability, $500,000 case, and the lawyer has the system set up for not missing the statute of limitations, but made a mistake and blew it. And so the lawyer has now discovered that that he missed the statute of limitations, and the question is, what should he do now? Okay, so he hasn't told the client yet, and you know, the situation that the lawyer is in is saying, oh Jesus, look what happened to me, and how the lawyer relates to the client in that context is really kind of important, and it's just filled with ethics problems. So, what should the lawyer do at that point? Do you think?
Well, let me answer that question with a question. Well, what do you guys think?
Yeah, what do you think?
What do you
That is
think?
a good question.
Yes, I always wanted to operate the Socratic Method. Yes.
I think I would certainly call someone who's maybe an ethics professor or a former professor that I've had, and just without spilling the beans as who my client is and the particulars of my situation, just maybe ask for a little bit of guidance.
It's good. Yeah. I mean, nothing
That's
wrong with
helpful.
that. Absolutely nothing wrong with that.
What happens in a firm like yours when this kind of thing
So,
happens?
so if this were happening to me, the first call I would make is to our general counsel. Not everybody has general counsels. We're a big firm, but we would. And in fact, Bill sent me these questions. I called my general counsel and said, okay, well, I call you, what will we do? The one thing that we think, and I think Professor Woodward agrees, is you have a duty to keep your client informed. And so in this particular case, I think you would have a duty to inform your client that you missed the statute of limitations for filing. The general counsel told me stories. So do you as law students, you get the California, is it the California Lawyer? What's the bar publishes?
There's the Recorder and there's the San Francisco Bar.
Yeah, it's not a big, but it's the thing. It's the magazine that you get from the California State Bar. That when you look at the back section, it shows all the lawyers who've been disciplined. Okay, so believe it or not, there are a lot of people who look at that. I call it the People magazine of law, and you read the things that they do. And one of the things that the general counsel told me was that he remembered a situation where someone missed the statute of limitations. What the person did was didn't tell the client, and then started lying, and that's the worst thing you can do. Okay, started lying, saying, "Well, yeah, sure, yeah, the case is okay. Oh shoot, we lost the case." I mean, really, he said the guy lied and told the guy he lost the case and thought it would go away, but of course the plaintiff said, "Well, would you send me the papers so I can see what happened?" Of course, there were no papers to send, so that's the worst case. So what you can't do is bury your head as much as you want to, and look at everybody makes mistakes. I make them all the time. It's how you deal with mistakes really is really the practice and business of law. We all make mistakes. We try to mitigate them and not make them worse. And the way you make them worse is not deal with problems up front.
Did any of you see a conflict of interest here? So when the lawyer misses the statute of limitations, does the lawyer have an interest adverse to the client at that point? Apart from the representation, they're still representing the client, but is there an adversity here? Because that tells you something about how you have to talk to the client. Well, does the client have a claim against the lawyer? So
There's your adversary.
there's your answer, right? There's your answer. The client now has a claim, potential claim against the lawyer. So what does that beget in terms of discussion with the client?
What I would tell the client is, we've missed the statute of limitations. Although I'm going to try to think of ways to mitigate or solve the issue. We have an adverse interest now, unfortunately, because of my mistake. Be careful what I say, but because we missed the statute. So you should talk to a lawyer. I mean, I would advise them to talk to a lawyer, and I would do it in writing, actually. The other thing I would do is thinking out ways I mitigate this. We're maybe in California, and the complaint should have been filed 2 years. Other jurisdictions may have longer statute of limitations, and one of the things you might think about is there a way to bring the case in another jurisdiction? Something I'm thinking about for sure. Now that may cost money, may cost time. The client may not be interested in that, but I would be thinking about that, because frankly that might be a way to mitigate my exposure if I miss this.
Now we had a little talk before. There's one little piece of this that is a hard problem, and that is the malpractice carrier. Because most of the time you're going to have to alert the malpractice carrier that you've got a malpractice problem. How that happens, and this is the general counsel problem probably at your place,
yeah.
So that they would be the ones that would do that. But the malpractice carrier certainly, if this claim had a 1% chance of winning, and the lawyer told the client, I screwed up, I'm now liable to you, the malpractice carrier might have a problem with that, right? Because it's coming out of their pocket. So there's probably an art to how one talks this through with the client, with the malpractice carrier kind of sitting on your shoulder. Obviously the malpractice carrier isn't going to dictate, should not be able to dictate how you relate to your own client, particularly when there's ethics issues.
Yeah, I don't think they can.
No, they can't. But they're going to have some interest in you not throwing their money away by saying more than probably you should say, which again is the adversity part of this, which is really, really hard.
So one of the things that, because I know we're a big firm, and I have to do with our insurance carriers, but even if we were a smaller firm, insurance carriers require certain things, but we certify each year, we go through a list of questions, and we're certifying, one of the things we certify is, are we acting as trustee of a trust? Lots of potential claims when you do that, so they want to know that. But one of the things is, has there been any, do you know of anything that has occurred, not that there's any claim that you've done or that has occurred that could potentially be a claim? We have to disclose those things.
Yeah.
So
Yeah.
It's always better to deal with these things earlier up front. There is, as Bill says, there's an art to how you do that. I mean, I can tell them the statute of limitations is run on the complaint, so I can't file it. Have I admitted any wrongdoing? No. But I said something factually that is true. But the other part is, I know this is the fact pattern,
Yeah.
but sometimes it's not as clear when the statute runs,
Don't
right?
fight the facts.
Yeah, I'm sorry. Well, I did. I am on the other one, though.
You're exactly right.
Yeah. So the point here is you have to deal with the problem, deal with it up front, and don't bury your head in the sand, because it'll get worse.
Good. Let me put the other problem up. We're not going to have that much time to talk about it. It's much harder because it's a transactional problem. And where is it? There it is. Okay. So now we've got the lawyer representing a client in a negotiation. The negotiation results in a decision by the two parties about a consequential damage waiver. And the lawyer doesn't put it in the writing. So the lawyer forgets, and this is common. When lawyers draft documents, often they use an old contract, and if you're not really careful, you can wind up using that contract in a wrong way. And that's what this problem sort of sets up, is putting a provision in there, or not putting a provision in there that ought to be in there, the waiver of consequential damages. Now, what's hard about this is there's no claim yet, and we don't know if there's ever going to be a claim. So in the last problem, it was kind of crystal that the lawyer had done something that would likely harm the client. You know, the likelihood was high that the client was going to be harmed by missing the statute of limitations. Here, it's really not that clear what's going to happen, but there was a mistake, and the mistake could have, you know, sort of time bomb effect somewhere down the road. So what happens now?
Yeah, this is a hard one, because if you think about it, if nothing happens, no harm, no foul, right? I mean, he sells the widgets and everything's fine. So, geez, do I really need to say anything? So, I mean, based on these facts, so this gets back to, if these are the facts as stated, without any color, which we're going to add a little bit of
And they're never that way.
Yeah.
But, yeah,
so a little color. I would, again, feel compelled under a duty to keep your client informed, that I'd be compelled to tell my client that this did not get into the contract. Now, does that mean I made a mistake? Well, a mistake was made. Well, and I say that. So
mistakes were made.
So, no, for example, what if there was a term sheet, and the term sheet said that there was a disclaimer of the consequential damages clause, and there's an agreement, but for some reason mistakenly it didn't get in. I mean, things like that happen a lot. Red lines and all sorts of inadvertence didn't get in. If it was clear the parties thought that that was the agreement and it did get in, I think you was a mutual mistake of fact. Is that the argument?
At least that, yeah.
So that you can do that. Sometimes, frankly, it's a Scribner area. Say, hey, that should have been in. Let's reform the contract. It should be included.
And so a piece of this is contract law. A piece of it is. But the ethics part is, you know, what do you have to do with the client? And you know, I don't know whether the carrier gets notified about this one or not. Probably does.
Yeah, you probably. I mean, I guess most carriers tell them early, tell them up front. It is interesting though. It's a harder one. It is a harder one because it could be something that doesn't happen. One of the things that happen is that it's still an executory contract. So perhaps you can use contract law to say, look, it's not. Let's say the person says, well, I didn't agree to that. I didn't agree to disclaiming the consequential damages. We say, well, wait a second. Contract hasn't been completed yet. That was the deal. Work something out. Maybe to renegotiate the contract. You may still be able to do that. This is one where statute of limitations. If you miss it, that's it. You're done. They argue that the statute hasn't run for whatever reason, but if you really truly do, it's done. This is more opaque. Frankly, this is an easier conversation to have than the other one, in my opinion. Things do get missed out of contracts all the time.
There are more solutions to this too.
What I told Bill is that the truth is that oftentimes when you have term sheets, for my practice, this is not a term that gets in the term sheet. It's a term that gets negotiated once the contract's been sent out. So I usually wouldn't have that argument to say, hey, we agree to it. We agree to it in principle or agree to it. Because usually it's not something that is treated as more.
To the extent that the mistake causes the client to have to spend more money either on you or on the contract or on managing the contract, et cetera, is that your dime?
It is my dime, yeah. I remember one case that I had that that our client, this is a real life case, our client had asked us to look at, so this is a real life situation, I'll tell it. So our client asked to look at the lease. It was a very big lease. And they were very concerned to make sure that we were able to have a certain number of people in the building. Very effective, there's no question. And a senior associate in the firm missed it, absolutely missed it. And it ended up in litigation, okay? I mean, it did, it ended in litigation. And this is a long-term client, and this helps to know who your clients are, having what I call decent clients. So we admitted right away it was a problem, it was a mistake. And he said, look, you guys are representing us in litigation, let's go through that and we'll deal with it after. And at the end, we ended up losing the case, shouldn't have, but we did. They had to pay, well, they wanted to settle it, they didn't want to go through litigation. So I think we would have won, but anxiety, whatever they wanted. So they could argue, but for the fact we made a mistake, we wouldn't be in this litigation. So there was damages for $5 million. And what they could have said is, okay, we've been damaged $5 million, you got to pay us $5 million, and we're not paying you any of your legal fees, we're not paying all stuff. But that's not what happened. What happened was, hey, we're going to help you on these fees, but not all of it. And they said, we're going to pay your bill, not all of it, but we worked something out that was mutually respected by both parties, thought that was fair, and it's still been one of our big clients. And
What happened to the $5 million?
There's some insurance that helped cover a lot of that. So it helped part of it, but we paid for some of it. But they paid for it too. I mean, they could have blamed themselves. I mean, we could have been jerks and things, but there was a relationship here that when you have relationships, and this is not always the way it works in the real world, unfortunately. Long-term relationships help with these types of things, but it's also, this is why you want to know your client. You don't always get to know your client. But some clients, unfortunately, aren't good people. Just not. And I'm not saying, so they may try to take advantage. Unfortunately, we have to work in an environment where you have to work oftentimes towards the lowest common denominator, and that's hard to practice law that way. So you can't always do it. That meaning, like, what do you send a CYA letter every time you talk to somebody? This is to confirm our conversation. Never happens. Can't afford to do it. Clients can't afford to pay for it, and it's really not practice law. And frankly, you piss clients off because what do you send a CYA letter? So it's a balance. Yeah. It's a balance. But the one thing I found in life, having done this for 30 some odd years, is that if you deal with people who are honest, have integrity, think mistakes can get made, but there's a way to work through those.
So it's basically problem solving, but it's real common, and that's that's our whole reason for having this part of this. What I had suggested to Chip was that we end a little bit early, so you all could just get a chance to talk with them a little bit, and so
eat.
If you got questions, what we should have, we should get any questions that you have about this stuff. Most law firms of any size have ethics committees or ethics partners or something like that. I mean, when I was practicing, probably every couple of weeks I'd have something that I have to go talk to somebody about. And it just keeps coming up over and over again. Confidentiality,
conflicts of interest,
conflicts, all kinds of stuff.
Silicon Valley, you have a law, you're representing the investor in a VC deal, and now the investor wants you to be counsel to the company. Happens all the time. And then, okay, fine, now you're counsel to the company, you got the waivers and everything, and now the client wants you, well, you're company counsel, but we're going to do a financing, and we still want you to represent us. You're kind of representing everybody. I mean, I'm telling you that all the time. That happens all the time.
Yeah.
So you have to get waivers.
And there is in the section there is a professional responsibility committee. They will, I don't know what they're talking about this time, but often they're talking about things like conflict of interest. and ways that, you know, how does a law firm that has a lot of lawyers and a lot of clients and therefore a lot of potential conflicts, how do they manage that stuff? They'd be talking about that kind of stuff. They would be commenting on proposed rules about professional responsibility. If you have any interest in this stuff and it's something that you're going to encounter on a weekly basis, that's another place to go at the meeting if you find something interesting. So anyway, we're going to quit at this point unless you have any more questions. And yeah.
So I'm interested in tax, and I was wanting to get
Tax?
your
He's a tax man.
just get your opinion on how it is to get into the market with the LLM and taxation, because that's what I'm going to try to do here at Golden Gate. So, what is your opinion about how that looks when you're seeking?
Well, you got an LLM in taxation, don't you?
I do.
There you
go. Yeah. So for the business law section, we actually have a tax committee. I don't know how active it is. I mean, it's not as active if you were a member of the tax section. Mm-hmm. And every member of our tax committee, and I'm a member of the tax committee too, is active in the tax section. Look at every transaction has a tax consequence. That's why we've got my LLM. And so I think it's important. It's important. Now, I don't know if we have too many tax lawyers. I don't know. We just hired somebody who has a tax LLM. So it's just a matter of getting out there and letting people know. But I mean, if you want to practice tax, having an LLM, I think is clearly an advantage in my view. That's
but even if you just want to do transactional work, an LLM is going to be an advantage on tax because it's just a piece.
Yeah, I'm not even a member of our tax group anymore. I'm the corporate finance guy, but I do a lot of venture private equity fund work. So I use a lot of what I call subchapter K partnership tax, top partnership tax at Santa Clara many years ago. So I still love it, but I just found that my practice morphed into the finance side of things. I mean, taxes. When I was at a boutique tax firm in San Jose, that allowed me to do corporate transaction work because it was a smaller firm. You sort of did everything. When I first started, and then I moved to Buffalo, which is a different experience. But obviously it worked out for me, and it helped me, I think helped me be a better lawyer for sure. Yeah.
Others.
I had a student today who came and asked whether she thought it's a good idea to get a joint JD MBA if you're interested in business law. And I had the conversation I would have with her about my perspective on that, but I'd love to get your perspectives on it as well.
So for me, I actually think it's helpful for what I do in corporate finance. But the way I say it's helpful is, believe it or not, what we do in the corporate finance world, if you know Excel and be able to work with Excel fastly, you don't have to get an MBA to do that. But anybody that there was one of my associates who ultimately became my partner, and now she's general counsel of a large company in Silicon Valley. But before all that, when she was a young associate, I said, Amy, how'd you know how to use Excel? Where'd you learn that? I got my MBA, and I forgot she got her MBA. And so I realized that is definitely beneficial. I mean, look at all those things are helpful. I think knowledge and experience, all those things are great. If you're interested in doing finance work, corporate finance work of any type, having an MBA I think is really helpful. If you're a litigator, is having an MBA helpful? I'm not so sure it is. Although if you're doing commercial business type litigation, maybe it is, probably is, could be helpful. I mean, having that experience, I would think it would be.
Yeah, I think it depends on where you're coming from. I mean, certainly transactional work is helpful, but if you have a business degree already, I'm not sure that you need more. If you have a history degree or an English degree and you don't know a damn thing about finance, then it's different. At my old school in Philadelphia, we had a baby MBA, which required students to take finance, statistics, accounting. I think those three were the main ingredients of it. And those courses, if you can master that stuff, you probably got what you need to practice law in the area. Now, if you wanted to do business, then it's a different ballgame. And you know, if you wanted to go on the business side, not the law side, not a lawyer's thing, but a JD enhanced CEO job, then an MBA is probably really handy. It just depends on where you want to go.
Yeah.
And where you're coming from.
I agree with you. My older son has a business degree, and we talked to him, you gonna go to business school? He goes, no, I mean, I got a business degree.
Yeah.
Of course, he went to med school, makes me worse.
Anyway.
But on the lighter side, but I will say is the MBA, I mean, it's interesting because when I chose my LM, one of the things I was thinking, should I get an MBA? I think about that. For me, it was the right thing. I will say, it's not, to Bill's point, it's not always beneficial just to get another degree and get another school. I think if you have aspirations and someday to be in council, in-house council, and be more than just council, be VP of business development and council, clearly that's going to help. Absolutely will help.
Yeah, I have a former student who went to work at Hewlett Packard after he went and took I think he got a master's in computer science because he didn't know anything about that. And you know, it sort of depends on where you're going. And if you're going to go in-house, in-house is a lot more business than being a lawyer. And being a lawyer in-house is a lot more business than being a lawyer outside a company. It probably helps because understanding finance and understanding the way all of this stuff fits together is really helpful. But you know, you could pick that up later if you wanted to. You know, if you knew, you know, one of the things that I think is important to understand is you don't really know where you're going. You know, you get the first job and you like this. You know, I mean, you were. You know, my life was the same way. You don't quite know where you're going. You see another opportunity, and boom, you're over here, and then you're over on this side, and so you can overplan it, you know. But a lot of it is luck. A lot of it is being available for the right opportunity.
Yeah, some people say if you have a CPA background, you really need. I mean, and you do tax. Do you need a LLM? Maybe not so much.
Probably
perhaps. I mean, I went back to NYU to get my master's in tax, and I went back because I was interested in theory, why we tax, how we tax. Some people go back there because they were CPAs, and I have to say the one thing about a tax program, which was my epiphany moment, was that you read the code and it's like 2 volumes and like this. And it's complicated, it's cross-reference after cross-reference, it's exception upon exception, but believe it or not, it all ties together. If you really, so you had that 1 year where you got to really spend all your time with it, to me that was really inspiring. So,
anyway, we're going to quit. Thanks for coming, and we will see all of you at some of these receptions at least. The food is really good. Anyway.
Thank you guys.